Well, hello, boys and girls, and welcome to Business and Its Environment. It's another gorgeous day here in Vermtown. The students are out running around in their Speedos and enjoying the gorgeous sun in our 35-degree weather with a blizzard predicted for tomorrow. But we're in the banana belt of the Midwest. Well, today we're talking about civil rights, women, and diversity. Clearly hot topics today as the Weinstein case and so many others are bringing to the fore of public discussion, not to mention courtrooms. So we've got lots to talk about today. We do indeed. So I guess probably the best place to begin our discussion is with that really incredible term, discrimination. We often view this term in a negative light, when in fact, all of us, every day, discriminate. So we pick which clothes to wear, what we desire to eat, who we're going to hire, who we're going to promote, who we're going to give assignments to. We make lots of discriminatory choices each and every day. But our quest today is to parse lawful from unlawful discrimination. And so we're going to be talking about a number of pieces of important federal legislation that I want you to be sensitive to because it certainly affects the workplace. The introductory story in your chapter 17, dealing with employment and the Non-Discrimination Act of 2009, is not law yet. It has not been enacted by Congress. It's actually been introduced into every Congress since 2009. But the nature of the bill is to extend workplace civil rights protections to gays, lesbians, bisexuals, and transsexuals. Clearly, our society's mores, that is our customs, have evolved and have changed over a period of time. And so let's take states like California, have enacted state laws that protect the workplace civil rights of people who are in the gay and lesbian community. And so we're going to review today a number of the protections that are already in force that make it unlawful to discriminate against certain classes of people. However, to date, other than the state laws that I referred to, California, for example, there is no federal law with respect to gay, lesbian, bisexual, and transsexual workers. But again, I caution you to look at your own state law because many states do have state law affecting the workplace and discrimination. So clearly there has been, efforts for a long period of time to evolve the changes in our cultural mores into legal enactments. I think we need to probably go all the way back to our Declaration of Independence because it did, in fact, establish a ideal, if you will, of common rights that are endowed to all members of our country. And so such ideals as equality, justice, human rights, freedom, and opportunity, I think most people could agree that those are good ideal rights that we want to seek to enforce because it has a historic foundation that goes all the way back to the beginning of our country when we declared our independence from Great Britain and struck out on our own. So it identified for the first time what we simply refer to as unalienable rights, or if you will, natural rights to which all people, whether you're a citizen in the United States or not a citizen in the United States, so certainly green card holders and visitors, who are here have unalienable rights that are protected by a variety of laws we're going to look at. Certainly, natural rights exist on a higher plane than civil rights, or rights that we bestow by governments, such as state governments. Civil rights guarantees have to be measured against natural rights to which all people are entitled. So the Constitution is obviously a document that implements into organizational form the ideals previously referred to in the Declaration of Independence. And specifically today, we're going to be examining the workplace discrimination situation that many employees and employers find themselves involved with from time to time. So the Constitution certainly has given many rights in 5 clauses, and then we're going to take a look at, it's certainly the Constitution contained provisions that protected the interests of slave owners. But as we're going to see, we've evolved beyond that point, and our Civil War, 1861, for 4 long, almost 5 years, we went through an incredible war that resulted ultimately not just in the victory of the Union forces. More importantly, it paved the way for the enactment of constitutional amendments. So, for example, after the Civil War concluded, the 13th Amendment was enacted by Congress and passed by the states, and the adherence of the former Confederate states to the 13th Amendment was a condition for their being allowed to re-enter the Union. And it abolished slavery. The 14th Amendment, enacted 3 years later, made it unlawful for states to pass discriminatory laws that deprive citizens of their rights. What rights? The unalienable rights that we discussed before. And then the 15th Amendment prohibited race discrimination in voting, and we'll talk more about that in a moment. So civil rights measures, including acts prohibiting employment in 1866 and prohibiting discrimination in transportation and accommodations in 1875, set up a mechanism by which freed slaves' rights were protected. So it has a historical foundation. It is not just something unique to the 20th century. And so for a period of time, those laws were sufficient to try and reconstruct the South. However, there's an interesting historical anomaly that occurred in the presidential race in 1877 between presidential candidates Hayes and Tilden. Well, neither one had sufficient electoral votes in the Electoral College to be elected president. And so the wheeling and dealing in 1876 resulted in candidate Hayes promising that he would remove federal troops from the South who were there physically, if you will, occupying the South and enforcing the laws that we previously mentioned and the 3 constitutional amendments. But Hayes promised to remove them, which certainly brought him the electoral votes he wanted from those southern states, which made him president. But the result was, with the withdrawal of troops, the protection over minorities evaporated. And of course, the states were re-allowed, if you will, to engage in Southern racism and other types of heinous behavior. The civil rights cases in 1883 saw the Supreme Court hold that Congress lacked the authority to regulate race relations between private citizens. Wow! You're probably thinking, wait a minute. It said, look, the private wrong of race discrimination in transportation and accommodations, is trying to prohibit that is unconstitutional. Congress doesn't have the authority to prohibit private behavior. Well, the worst case I can think of in terms of trying to override the earlier civil rights statutes involved a case in 1896 called Plessy versus Ferguson. Now, this was a case where we had a gentleman, Plessy, who was attempting to ride on a railroad passenger car that had a sign on it reserved only for whites. And he was, I forget, a percentage of a black American. And so he refused to move, and there was a state law in Louisiana that made it unlawful for people to ride in cars that were not consistent with their race. And so the Supreme Court held that this was lawful, and that under the 14th Amendment, state segregation laws were permitted, providing the accommodations and the services were separate but equal. Well, of course, we know historically that while we may have had separate transportation and other types of facilities, they were inherently unequal. And so that brought us up to, if you will, Brown versus the Board of Education in 1954, where we saw the Supreme Court unanimously overturn, that is, reverse, Plessy versus Ferguson, holding simply that separate inherently means unequal in public places, transportation, schools, and business. And so the Supreme Court did a 180 turnaround with respect to prior precedent, and that really reinvigorated not only the earlier civil rights laws, but certainly the three constitutional amendments. This certainly affected others besides Black Americans. It affected certainly American Indians, Hispanics, Chinese immigrants, Japanese immigrants, and so forth. So, you know, the times changed. I think with Brown versus the Board of Education, it essentially, I think, certainly served as impetus for the civil rights movement to progress and expand, all the way to Congress finally enacting in 1964 the Civil Rights Act of 1964. Now, remember, President Kennedy was assassinated on November 22nd, 1963. Now, the Civil Rights Act had been introduced, but with Southern Democrats and all, it was impossible to get it passed during the Kennedy era. Well, after his assassination, there obviously was a strong civil rights movement that had been ongoing as a result of Kennedy and his Attorney General, Bobby Kennedy, forcing Governor Wallace in Alabama to stop blocking the door for Negro students who wish to enroll there. And so I think as much credit is given to others, I think the assassination of John Kennedy served as the trigger, if you will, I don't mean to be facetious, in moving the Civil Rights Act bill forward and finding it being enacted in the summer of 1964. Now, within the Civil Rights Act of 1964, Title VII has a specific part that says, look, it is unlawful to discriminate on the basis of race, color, religion, sex, or national origin. Now, it wasn't perfect, but it certainly was a start. It specifically outlawed disparate treatment, or that is, unequal treatment of employees based on race, color, religion, sex, and national origin. So you may recall, or you probably have seen the black and white films of demonstrators attempting to eat and use, separate but not equal facilities. And, it remained for future years to have evolution and for the law essentially to catch up with society's movement. So in the case that you had to look at today, the Griggs versus Duke Power Company case, a 1971 case, struck down an employer's high school diploma requirement in a geographic area where blacks had very low graduation rates. The employer was unable to show that there was a relationship between the requirement to have a high school diploma and the work that was involved. And so it was seen as a discriminatory action or behavior and ruled unlawful. And so Title VII outlawed disparate impact. In 1978, we had the Equal Employment Opportunity Commission that defined illegal disparate impact in the 80% rule. So that's an interesting rule that applies to this very day. As originally passed and enacted, Title VII did not require affirmative action, but defined policies that sought or encouraged or sometimes gave preferential treatment to employees in the groups it protects. So it didn't require affirmative action, but as we're going to see, that came about later. Even President Johnson, and I have to give credit to President Johnson for getting Kennedy's Civil Rights Act of 1964 passed. He was a master legislative navigator, and having been, former majority leader of the Senate, he was crafty and wily and got the Southern Democrats on board to get the Civil Rights Act passed. Well, he also issued an executive order, that's an order signed by the president, that required affirmative action by federal contractors. That is, if you had a private contractor in a contract selling stuff or providing a service to the federal government, there was a requirement in the contract that the contractor, as a component of the contract, had to engage in affirmative action. The United Steelworkers versus Weber case, the Supreme Court, the Supremes held that Title VII permitted affirmative action plans that even led to reverse discrimination against white workers if the plans were designed to try and break down past discrimination. So, for example, if you had historically only hired whites, well, in order to try and balance out the demographic of your workforce, you may need to now hire minorities until you can try and reach some type of reasonable demographic composition. Since the Weber case, the Supreme Court has taken a series of decisions we're going to look at here in just a moment. So there are lots of arguments for and against affirmative action, and it has essentially addressed these following subjects. We're all familiar with utilitarianism, right? That says, look, decisions that produce the greatest good should be the ones that we engage in ethically. And so affirmative action is targeted towards the greatest good, not just the individuals involved, but the perception that all of society improves and gains from diverse, not just employment, but education and related activities. While there certainly may be inconvenience experienced when affirmative action seeks to try and remedy historical discrimination, but as we're going to see, that has evolved and changed too. Compensatory justice requires that those who are wronged by past discrimination should be compensated, and really affirmative action is intended to try and address that. Conflict between different spheres of justice certainly is what makes the problem of affirmative action, irreconcilable. That is, certainly we would agree that, the ends don't justify the means, and we've had problems with that, as we're going to see. So let's talk about women in the workplace, which is obviously a hot topic for conversation these days. Certainly women are entering the workplace in larger and larger numbers each year. So I love the Mark Twain phrase, there are three kinds of lies. There are lies, there are damned lies, and there are statistics. Well, one statistic is that, worldwide, 52% of women enter the labor force compared with 78% of men. And as you might expect, participation rates are highest in the least developed countries of East Asia and Africa, and lowest participation in Arab nations. Why is that? Because women culturally are expected to stay at home in many of these Arab countries. And certainly in different cultures, men and women socialize into very distinct sexual roles, which are different from those, for example, experienced in Western countries. Now, there certainly has been a change. So let's use Saudi Arabia, for example. More women are entering the workforce in Saudi Arabia than ever before. And there's been a dramatic evolution in the change of the role of women in Saudi Arabia. And so stay tuned for further changes there. Certainly, there are discriminatory actions that happen in the workplace involving women. Certainly in the past, physical attractiveness, marital status, potential for motherhood have all been issues that have created, serious injustices. So, for example, when I was going to undergraduate school, there were several women in my class who were pre-med students trying to get into medical school. And none of them were successful, even though they had grades and MedCat scores that were higher than their male counterparts. When I asked some pre-med faculty advisors, why is it? Because one of these girls was a girlfriend of mine for a while. And I was irritated, that why was she being discriminated against, because she had better grades and a better MedCat score than her male counterparts. Why wasn't she getting admitted to medical schools that the men were? Well, the pre-med counselors told me, well, it's because they think, the thinking is the medical school faculty think these students are going to get pregnant, going to get married and drop out of medical school, and so waste a slot. And that was the thinking of the time, and so they weren't admitting them. And I thought, really? Is there any data to show that? That's something new to me. I'd never heard that before. And certainly, I think we have to concede that workplace cultures are based on masculine norms. Why is that? Because men have occupied positions of authority and supervision. And so advancement, in positions often can be culturally different. So, for example, if you have children, it's more often than not, women are going to need to leave at reasonable hours to pick up children and care for them. Now, we're certainly seeing more men provide child care, attention, and activity, but I think we can still say, as a general rule, women spend more time and effort on child care than their male counterparts. I know I had a wonderful lawyer who worked for me, and she was forever, coming in late because she had to take the children to the doctors in the hospital because of ear infections. They needed ear tubes and whatnot. And so she was forever having to do all this child care. But her husband was also a military officer, but he was never doing this. And I asked her, why is he getting a free ride here? Why can't he take the children to the hospital too? Because we seem to have an unequal work situation here. And so she eventually did train him to take over more of the child care responsibilities to make it more fair. So that's a problem in the workplace. Women may not be able to stay as late as men because of the child care issue. But with men assuming more and more responsibility, hopefully in time that will even out. And certainly it's true. I mean, because I've had a number of cases that I've had to deal with involving sexual harassment. Certainly annoying or persecuting behavior in the workplace that, certainly causes discomfort, embarrassment, anger, humiliation, which we simply, characterize as sexual, harassment. There have been the Equal Employment Opportunity has issued guidelines on this, and there are two situations where I think most reasonable people would agree harassment is illegal. The first one is the quid pro quo situation, where submission to sexual activity is required in order to keep or get a job. We certainly have heard that on television, right, with some of the women who have filed suits against the president that in order to get certain things on his television shows and whatnot, they were having to submit to fun and games. The other situation, of course, is the hostile work environment, where there is sexually offensive conduct that makes working in the environment difficult. So, for example, when I was running a legal office in Germany, and I had more than half a dozen women working for me, I had one of them come to me and said, look, she had a personal problem. And I said, sure, what's up? And she said, well, in all the workspaces, men have these Playboy centerfold pinups, and they've got them pinned up in their office area, showing these, mostly naked women. And they've got to come work in these work environments, and they find it sexually offensive. To my complete shock, I hadn't noticed. I hadn't noticed. And I said, really? So I went around and checked everybody's cubicle and work area, and doggone it, she was right. People had all these lurid Playboy, pinup centerfolds. Well, I had to, get everybody together. We had a staff meeting saying, all right, boys and girls, hey, this is childish. Take that stuff down. And the same thing goes with, sexually offensive jokes and racially offensive cartoons and whatnot. Come on, we're better than that. We're better than that. Knock it off, You're creating an environment that, people are not proud to work in. And that includes me. I didn't realize it. I just didn't, because I didn't notice what people had on their walls and whatnot. So that creates a hostile work environment. And I think workers have a right not to be forced to work in that type of situation. In this case, Harris versus Forklift Systems, which is not that old a case, the Supreme Court set out a simple guideline for what constitutes a hostile work environment. While there isn't a precise test created, the standard is, would a reasonable person find the environment abusive? Harassing conduct is to be evaluated based on its frequency, its severity, and its unreasonable interference with work, and its humiliating nature. So I think those are all pretty obvious circumstances. So we've had lots of cases of occupational segregation in jobs. Certainly the Walmart case of where assistant managers who were women were paid less than their male counterparts. And so there was a settlement on that. And there have been numerous cases filed where they're performing the same work, but of course not getting paid the same salary. It is true, of course, that just like men, women dominate certain occupations, such as school teachers, secretaries, and receptionists. Fine, that's good. Clearly, you're dealing with the willing, people who willingly, want to engage in those professions. And same thing in the male area. There are certain things that, men like to do that, women don't like to do. So you don't see a whole lot of women who are firemen. Why is that? Well, it's not something that really attracts a whole lot of women. So you're still going to have those situations out there, but I don't think that is a bad thing one way or another. So I think we could mostly agree that women are underrepresented in some traditional male occupations such as manufacturing, construction, and craft work. Women are often 5% or less of the workers in those occupations. And again, I think some of this is preference, but some of it may be discrimination. And so I know in their department situation, there's a test, that obviously a written test and a physical test, that all applicants have to take. And, if you've got to be able to lug a fire hose or a ladder that weighs, 150 pounds, well, whether you're a male or a female, you got to be able to lug, the ladder or the fire hose. And if you can't do it, well, you can't do it. And that's a problem. Certainly you've heard about the glass ceiling in business, right? That women can rise to a certain level, but then when it comes to getting to the very top to be a CEO or a COO or even a CFO, you don't see that many represented. In fact, even as far back as 8 years ago, only 7.6% of top earning executives were women. I think we're headed in a better direction, but we have a long ways to go. It is the Equal Pay Act, a federal law of 1963 that forbids sex-based pay differences. And so if it's the same job, regardless of what you call it, regardless of what job titles you use, if it's fundamentally the same job and you're paying different wages based on gender, that's a problem. That's a violation of the Equal Pay Act. So there have been certainly improvements. The pay gap is narrowed from 59 cents for every dollar earned by a man to 81 cents in 2010. So we're seeing some improvements, but we've got a ways to go. And it's not unique to the United States. This is certainly a worldwide problem, as reported. Diversity management, everybody's familiar with that. Certainly we all want workspaces and places that are friendly and inviting, and everybody likes to, have a variety of different types of folks. It enriches our work environment to have people of different cultures and genders. I think that's the operative term. They enrich the environment, and having all of one gender or race or ethnic group, I think, is not as enriching as having a mixed one. And so categories of diversity are quite naturally numerous. Some people think, workforce diversity creates tensions. I think there's some truth to that, where people perceive injustice. Is somebody getting a job or a promotion primarily because, they're white, or because they belong to a minority group? I think everybody can see how that's not going to, and that's going to create tensions and not necessarily work in everybody's favor. And so it's important that, personnel actions not only be transparent, but, I think management has to explain from time to time, why people are being promoted, because, he or she is really creative, imaginative, enthusiastic, industrious, and so forth and so on. And certainly, it's not unusual that, look, having annual training, sensitivity training. So, for example, I found sensitivity training in the Army to be extremely useful and extremely helpful because I was insensitive myself in a variety of situations. And fortunately, the one thing I always tried to get people that worked for me to do was to be sensitive and be candid with me. Give it, or as I like to say, give it to me with a bark off. And sometimes, I would find out that there were things I was doing which were really embarrassing or hurting other, people. So, you need to rethink your behavior. And again, I think your work environment is enriched by having candid people who, call you out in a respectful and nice way. I think at the end of the day, you'd rather hear from your subordinates than hear from your superiors about behavior that, is frustrating and perhaps embarrassing. So, for example, when I came in the Army in 1976, yelling was a problem. Sergeants used to yell at the privates, and the privates would yell at each other, and officers would yell at the sergeants. And good Lord, I didn't like being yelled at, period. And so when I took over responsibility for being an officer in charge of an office and a staff judge advocate of a legal office and all, one of the first things that I laid down as a rule is no yelling. No yelling. Nobody yells here. I know the Army likes to yell, but we don't do that in a legal office. No yelling of any type. If we've got a problem with somebody, let's sit down and talk. No yelling ever. So I had a sergeant who transferred into my office, and I hear this bellowing down the hallway this one day. And man, I had to nip this one in the butt. I came out of my office in a heartbeat, trooped down, grabbed him by the arm and said, "Sergeant, in my office, like now." I got him in there, and of course everybody in my whole office knew what was going to happen. And I said, "We do not do this here. There is no yelling in this office ever. It's disrespectful and people do not like it, beginning with me." I said, "So no more yelling. I realize other environments you've come from, they may yell. We do not yell in this office, okay? It's disrespectful." So that's one occupational environment characteristic that I suggest offends most right-thinking people. No yelling. No yelling. So yes, I think it takes leadership from the top. And when you've made mistakes, and I have made more than my share of mistakes, I think confession is good for the soul, is good for the soul. So when I had to admit I hadn't noticed the Playboy pinups in the work cubicles of my enlisted personnel, I hadn't noticed it. And I should have noticed it. I wasn't paying attention. Because if I had been paying attention, I think I would have been as embarrassed as our female employees are. So boys and girls, take them down. Now, you want to take them home, put them up in your apartment, have at it. But in the workplace, let's be respectful of one another. Changes in organizations, affinity groups, support networks for employees. Hey, these are, helpful. But I think doing things together rather than separating employees out is important. Training is crucial. And so I think ethics training and diversity training are really interesting subjects that need to be, if you will, even from the top down, everybody needs to be retrained on an annual basis. When I came into the Army in 1976, we had 2 hours of training a year, as far back as 1976, in ethics and the law of war. And eventually, in the 80s, we morphed in diversity training. Mentoring. Certainly, mentors are a superb idea in the workplace. And so when I came here to teach at the University of South Dakota, I'm proud to say I asked Professor Tom Davies. He wasn't even in my division. He is an accounting professor here. And I approached him and asked him, as you know, since he was an experienced faculty member, if he would be my mentor. And so we went to lunch every week for my first year. Because I would ask him about, so what are the grading policies here? What are the sensitivity, issues that, are problems here? And I learned a lot from, being mentored by Professor Tom Davies. And so to this day, we're still very close friends. And so I think you sometimes have to seek out mentors and ask someone to be your mentor, who, if you will, can be a coach and at times a critic and sometimes a fan. Because again, I think you'd rather hear about problems from your subordinates than hear about them from your superiors. So let me give you another example. I noticed after I took over this office that come 5 o'clock, nobody went home. And so it got to be 6 o'clock and 7 o'clock and nobody's going home. And well, I knew everybody had families, but I didn't. I was a bachelor at the time. And so I thought, well, I guess, everybody's real busy. Well, I was busy. That's why I was still there at 7 o'clock. Well, this went on for several days. And finally, I had a sergeant who was in charge of my office. His name was Lonnie Bruton, Sergeant First Class Lonnie Bruton. And we would freely talk, and he was very candid with me, which is exactly what I needed. I asked him, what's going on here? Why are people staying past 5 o'clock? They should be going home. What's going on? Because I was afraid my subordinates were requiring their people to put in more work than I really thought was fair or appropriate under the circumstances. So I was trying to dig down and find out what the hell's going on. He looks at me like I'm from outer space. He says, Captain, the reason why nobody goes home is because they're waiting for you to go home. They will not leave until you leave. Wow! I didn't know that. I didn't know that. I mean, it hit me hard. I said, well, okay, we can fix that, starting today. So at 5 o'clock, I made the rounds. I made the rounds of the whole office. Went to everybody's offices. That's it. We're done. I'm headed home. Let's all head home. We're done for the day. And I made the rounds every day. And so, yeah, 5 o'clock, we're, headed out the door. Well, we're done for the day. Well, now there certainly were days and times when we had trials coming up that we needed to spend more time. But again, I think it was important to let everybody know that, look, I got to stay tonight because I got this trial coming up tomorrow. The rest of you turkeys, come on, head for home, so forth and so on. So I think that's an important characteristic. It's called management by walking around, getting out there and being visible. When I was at the Air Force Academy for a year teaching, our department head, Colonel Parag, he came around every single day to every single officer to check in with them, to see how they were doing and was there anything, that he needed to pay attention to. I thought that was great mentoring. Certainly data collection, data, is important. But again, as with Mark Twain's, saying, you got to be careful that, it doesn't drive your entire decision making. That qualitative decision making is important too. And certainly new policies to adapt to the needs of diverse employees. I learned that when employees had special needs, they had a dental appointment, they had a child that they had to take to the orthodontist and whatnot. Hey, we were on the honor system, and I told them, well, figure out how you're going to make up the time. It's totally up to you. You want to sacrifice a lunch hour later in the week to make up the time, come in earlier, stay a bit later. Hey, whatever you want to do to make it up, hey, that's up to you. That's great. And if you empower employees to do that, and again, you don't want to be playing favorites in terms of sexual preferences or racial preferences. Everybody's got to know what the rules are. And so the Army did not want to pay overtime. And since I didn't want to do that, but of course, occasionally people do need to work late, how do you handle that? Well, I just had everybody on the honor system that I asked them each month to provide me a list of the additional hours that they had worked beyond what was required. So I could get even with them by making sure they went home early on Friday, or they could take the time off whenever they wanted. And so we had a real flex schedule type of thing that the employees really appreciated. It gave them a lot more flexibility. And if they were going to be late or whatever, they'd always call in, that they were going to be late because they had to take, Johnny to the orthodontist. Hey, it's great. The world is not going to come apart at the seams because everybody is not there at the same time. Get a grip. And I think, positively reinforcing good behavior is a good thing. And the military was very good about that. That's where decorations come from. And I've always thought handing out awards are not just for the people who are receiving the awards, but everybody else who is observing the award ceremony are thinking, well, if I do my duty to God and country and it comes time for me to receive an award, I'll get one because the institution rewards good behavior. So are there, still tensions in the diversity situation? Yes, there are, but I think the more people that work at it, the better the situation becomes. When I came here to the university in 2003, in our business faculty of 40 faculty, I think we had only like women, maybe 4. And we set as one of our diversity goals was to increase the number of women on the faculty. And as a division chair, I served on every search committee, and that was a factor that I was looking for as we were searching for more qualified women faculty. And so we didn't have any quotas or anything like that, but we were affirmatively recruiting, seeking, considering women to join the faculty. And so today, here 2018, I would bet half our faculty, I bet we're up to 50% of our faculty are women. That's a great improvement, a great improvement. Why? Because we set out over a period of time to make that happen. Yes, it's true. Prejudices can be deeply rooted. I know in my own family growing up, there were racial prejudices that intellectually I never could process. I couldn't understand why color had something to do with good or bad. So, for example, red, green, and yellow. Red, green, and yellow. Which color is the best color? Red, green, or yellow? Colors aren't better or worse. Colors are just different. Well, and so it is with people. Yes, people have different colors. They're not better or best. They're just different. And so I never quite understood that with my own family. And once I got into the workplace myself, I did everything I could to identify those that just didn't get it. And I had a few that worked for me that just clearly came from environments that were deeply prejudicial, and I wasn't going to convince them. And so those people had to be sent on their way. Oh, let's see. Yeah, that's true. When people believe their status is threatened, we all have a tendency to resist change. Alvin Toffler, in his great book, Future Shock, he says, hey, the one constant in life is change. Well, I think that's true. But you've got to be what I call rigidly flexible. Rigidly flexible. Willing to change. The Adirond versus Pena case is very, very famous Supreme Court case. And that, we had essentially an affirmative action program that was being operated in Colorado, and you had contractors in Colorado who were bidding on a guardrail project. And despite submitting the lowest bid, a Hispanic-owned company got the job. Well, obviously, that's going to irritate the other contractor, and so Adirondack, sued, arguing, hey, he had been discriminated against in this contract awarding, and that there seemed to be some preference, affirmative action or quota that got this higher priced contract to the Hispanic-owned company. So he was determined to fight this out. 12 years fought it out. And what was the constitutional issue that the Supremes considered? Whether a federal affirmative action program favored some citizens over others based on race, ethnicity, and sex, whether or not that's constitutional. If you will, reverse discrimination. So, what is the constitutional protection? The Fifth Amendment reads, no person shall be deprived of life, liberty, or property without due process of law. And so Adirondack is arguing he was deprived of the opportunity to engage in this contract because, not because of any operation of law, but because of this preference, this affirmative action, program. So, with respect to states, Section 1 of the 14th Amendment of the Constitution says very specifically, no state shall deny to any person within its jurisdiction the equal protection of laws. So, and that obviously put the state of Colorado in a bind, because clearly they were, unequally handing out highway contracts. So this provision certainly is binding on all the states, but not the federal government. But the Supreme Court has said, look, citizens need to be treated equally in terms of opportunity at the national level as well as the state level. And so it is, in fact, the Fifth Amendment that embodies a guarantee of equal treatment at the federal level, as strong as it is by the 14th Amendment at the state level. So what were the issues presented? Certainly reverse discrimination, right? We know that citizens are classified for different reasons. So certainly for taxation and for the age for licensing drivers and contracts and all sorts of things, right? So it is lawful to discriminate, providing there is a legitimate purpose, a legitimate governmental purpose that is being, served. And so if law sets up a racial and ethical, ethnic classification, then there's going to be a tougher test. And what is that test? Well, first, and using the Adirondack case as an example, first the government has to prove what's called a compelling interest. So what was the compelling interest that made Colorado provide contracts to minorities even though their bids were higher than white contractors? And so the burden's on the government to prove that their discrimination against favored groups exists and that their affirmative action plan is designed to end it. And second, the second requirement is that the government has to show that their program, their plan, in this case, awarding of state highway contracts, is narrowly tailored to meet the problem of discrimination. So, looking at the facts, we got the Department of Transportation, who ultimately had to revise its rules for awarding federal contracts to disadvantaged, that is, minority business enterprises. Well, So they've had to change because they could not meet those tests, the compelling interest test, and to show that the awarding of the contracts to minority businesses was a narrowly tailored remedy to combat racial discrimination. Didn't pass constitutional muster. So what do you think? Does the Supreme Court, do you think the Supreme's got it right? And so this essentially, if you will, eliminated quotas. And so quotas, that is setting aside positions, contracts, whatever, quotas of any type, favoring one minority group over another or gender group over another is not constitutional. So this doesn't eliminate the ability to engage in affirmative action. What you can do is treat affirmative action as a consideration, a factor in employment, promotion, and other types of positions. A factor, but not the controlling factor and not the only factor. So remember that those are the two legal standards that have to be met, that if you want to do an affirmative action program that has preference for a particular identified group, you're going to have to meet the two-part test. Is there a compelling interest in using the affirmative action? And second, is the proposed program narrowly tailored to meet that compelling interest? So even the federal government had to change its rules regarding paying bonuses to contractors who hired minority contractors. That, again, they couldn't meet, the federal government could not even meet the two-part test. So therein be the rules regarding affirmative action and discrimination. So I know we've come a long ways today. We've covered a lot of turf. As always, I invite your emailed questions, anything that I can do for you. Make sure you check your grades, boys and girls, to make sure I've got them all right and up to date. Shoot, move, communicate, right? Stay well. We'll see you next week. Bye-bye.